have a few we could
Yeah,
get out of the way, I think.
Okay, let me just say for our purposes, I've got 2 in Hart County, 1 in Laurel County, and 1 person in Wayne County. So, if we can maybe get those folks taken care of.
Judge, mine are the Wayne County and Laurel County, and both of
All
those will have to have hearings on.
All right. Well, all right, tell me what you've got if you have something agreed upon, and we'll just try to go ahead and process those.
I don't know if William Teller Froge is he in Barron County now?
He is.
That's one that we are going to have to, I guess, technically withdraw the motion and send it back down to Warren County due to that related case having been transferred by drug court. We need to transfer this one down as well for them to determine.
I don't know if, I can't remember which of the DPA attorneys was going to handle.
Josh.
But Josh, was it you?
Yeah.
Yeah. You remember the situation there? We just through oversight, sent one case and didn't send both cases.
Yeah, I talked to William a little while ago, and he had court with Judge Grice this morning, and I think Judge Grice was wanting both cases, or his attorney down there was asking that both cases be transferred down there. So that's my understanding of what's currently going on.
All right. Well, Candy, if you want to prepare that document, are you able to do that?
It won't let me send to KP. I've asked for permission for it to send to you. I'm assuming, hopefully, they will grant me permission for me to send to you the document.
Yeah, well, if you can't, I mean, surely I can get it pulled up and pull one of those forms up and transfer it myself.
Yeah, that was per Judge Grice as well. He wanted that as quick as, as quickly as we could to go ahead and transfer it to him.
All right. Just tell if KP doesn't get it, and if I don't get it, remind me and I'll go on the forms, because surely there aren't any forms that I can't access. What's the form number? Do you know?
I can send it to you via text. When I get it on Zoom, I can. I'm afraid if I pull up my handy dandy 1920.
Yeah, that's fine. Just send me the form number, okay?
I will.
All right. Fair enough.
You want to take care of another, I would hope that we could take care of Taylor Miller quickly.
Yeah, that's fine.
She was assessed last week by the social service clinician, I think down in Warren County, and recommended to go to RKC. And we'd be willing to amend the conditions of her probation for her to enter and successfully complete that program in lieu of revocation.
Monica, yeah, there we go. Miss Miller, did you hear that?
About rehab, making it the conditions of my probation. That's about all I heard.
Correct.
Yes, sir.
Judge, I don't know if what stage it's in as far as getting her a bed date or anything. Taylor was just wanting to know if she could have like a day before she reports to it to get her stuff ready to go to take with her.
Yeah, I mean, I will do what I try to do whenever I get a notification of a bed date availability, which is to, unless I get something and says she's got to go, tomorrow at 9 a.m., then, I'll try to let her out in enough time to get some things taken care of and, dot some I's and cross some T's. It's just that sometimes I find out that your bed date is 4 or 5 days away, and sometimes I find out it's tomorrow. So, I don't have any control over that, but, if I can, I will give her a little time to take care of some things. Okay.
Judge, I'm just emailing the officer now to let him know she hasn't been on a list for a bed date. So I asked that she be added today.
All right, Miss Miller, we'll just kind of hunker down and wait. Okay.
Okay, thank you.
Thank you.
And as far as agreed cases, and then Margaret states on here, but she's in treatment. So I don't believe we have anything to do with that.
Yeah, I believe that one's taking care of itself.
And
those two.
The others I have are with Johnny or their hearings. So if Mike has anything that he can do that's resolved.
Well, I guess we could take up, I got Adam Williams on the docket, Judge. He was supposed to be evaluated, which he has by now.
Judge, he said SSC came over and assessed him and was recommending IOP, I believe.
Well, that was, I mean, I don't,
The-
is his officer on here? I don't see her on here.
I didn't speak to anybody, Judge. I'm willing to go. I think what I had agreed to, was willing to do, was that what he would do, whatever the SSC recommended, which I'll be honest with you, I was expecting a lot more than this, and I don't know if it's going to work, but we'll give it a try. But the time that he spent in, if he stipulates, can count as a sanction. He'd have to complete whatever the treatment's been recommended.
So that's the agreement.
Yes, sir.
Do you understand that, Adam?
Yes, sir.
Okay.
What you're going to need to do, Mr. Williams, is be sure that you report as soon as you get out to your probation officer and, you know, get your marching orders from her, okay, about getting your appointments set up and so forth.
Yeah, they told me what all I'd have to do, get a hold of life skills and all that.
All right. Well, she's going to need to know that you are out of custody. So be sure when you get out, you report to her, okay?
Okay.
Or call her or whatever it is, however it is that you all are making that happen these days.
Okay.
I know different offices are doing different things. Okay?
All right.
All right. Thank you.
Thank you.
Yeah, he's just doing a, in lieu of revocation, comply with the SSC recommendations and time served sanction. Okay. Who are we? All right. So it looks like maybe some hearings are in the mix. Why don't we start? I guess we can do this one in Laurel County. I see, I only say that because Miss House is the very first picture on my gallery here. So, who are we going to call in that case, Ms. Gardner?
Officer Williams.
All right. Is this, let's see, Mr. Spears, are you handling this?
Yes.
All right, very good. Officer Williams, can you raise your right hand, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. Go ahead, please, Ms. Gardner.
Officer Williams, could you please state your name for the record?
Suzanne Williams.
And you are with probation and parole in Pulaski County, is that correct?
Yes.
You've been supervising Andrea House.
For a very short time, yes, I was.
When did you begin supervising her?
Let's see, September 21st, 2020.
And at that time, was she supposed to go to a treatment program as a condition of her probation?
Yes.
And where was that program?
At Skyhope Recovery in Somerset.
Did she enter the program?
She did.
And how long did she stay there?
She got there September 21st and left October 1st. So week and a half.
And she did not successfully complete the program?
No,
Did she contact you when she left the program?
she did not.
Do you know if she contacted any other probation officer with your office after she left the program?
Not that I'm aware of.
Is the first time you've heard of her since that time when her, I guess, warrant was served at the end of December?
I actually didn't know hadn't heard anything until I got the subpoena for this case that she'd
Okay.
even been picked up.
Okay. Other than failing to complete treatment and then absconding, are there any other violations of her probation?
Not that I'm aware of.
Okay. I have no further questions, Judge.
Very good. Mr. Spears?
Officer Williams, how is it currently set up with your all's office about reporting? Is it only by phone, or can they come to the office, or how are they supposed to report?
Well, with Skyhope, where they're right next door to our office, I usually go over there and do their reporting. For her specifically, I went and talked to her in person at Skyhope on September 29th.
Okay. And I'm just making sure I understand, you said she never contacted you or anyone else in your office, any other probation officer regarding when she left, is that correct?
That's correct.
All right. And no further questions, Your Honor.
Redirect?
Nothing further from the Commonwealth.
All right. Mr. Spears, any proof?
I call Miss House.
Ms. House, can you raise your right hand? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Go
Miss
ahead.
House, explain to Judge Alexander, explain to the court, explain to the court what happened in terms of you leaving rehab after about 2 weeks.
My aunt passed away, Your Honor, and they would not let me attend the funeral. So I left to attend my aunt's funeral. I did not contact the probation officer in Somerset. I did contact the one I had in Laurel County, as well as the person in Laurel County, Megan Sims, who had done my initial intake review for me to be able to go into treatment. I called her the day, as soon as I made it to Laurel County after I left rehab. And it was Monday morning when I was able to get a hold of Officer Markham that I had in Laurel County to let him know why I had left. I did not contact Somerset. I honestly did not think to contact her because I hadn't, where I was in Laurel County. If I would have knew to contact her, I would have. That's why I left.
Okay. If you were to not be revoked and given opportunity, would you be willing to go back to rehab?
I would, but this is what I would like to say, if I may, please.
Go ahead.
When the warrant was served on me, I was working a full-time job. I have been clean since my incarceration in August, and I would love the chance to try to do IOP, and I'm also willing to pay for home incarceration while I am on IOP.
Nothing further, Your Honor.
Ms. Gardner?
Ms. House, you do remember meeting with Officer Williams at the rehab facility, correct?
Yes, I do.
And you do recall at that time she notified you that she was going to be your probation officer?
She did. Yes, she did. But where I left the treatment, I just assumed when I left treatment there, that she wouldn't be again. Does that make sense? I was just in a state of turmoil over my aunt passing away. I mean, I'm emotional just talking about it. But
since that time and the end of the year, you didn't report to Officer Williams, or you didn't turn yourself in. You knew you were in violation of the conditions of your probation by not completing treatment.
I did. I contacted. I actually had left messages.
The question was, you knew you violated your probation by not completing that treatment, correct?
Yes, I did.
Okay. I have no further questions.
Mr. Spears, any redirect?
No redirect, Your Honor.
All right. Ms. Gardner, any rebuttal?
I don't have any rebuttal, Judge.
Mr. Spears, any arguments?
Judge, looking through everything and given the testimony of both Officer Williams and Ms. House, I believe a sanction, in lieu of fully revoking her probation, I think a sanction would be more in order in this case. It is, based on Ms. House's testimony, she had an issue with a close relative passing away as she started rehab, which led her to leave rehab. while she did not report to Officer Williams, she has testified that, she did report to someone in Laurel County. I would just ask for her to have one more crack at this and give her sanction for the length the court deems appropriate, place her back on probation, and have her be reassessed by the SSC for possible treatment, either go back to Sky or to whatever they feel is necessary.
Ms. Gardner.
Your Honor, I think that Ms. House has been given several chances over the past year. She had 2 pretty quick DUIs, and at that time her diversion was voided, and she was given the opportunity to address her addiction issues by going to treatment back in September, and she didn't last very long. She knew that she needed to report to Officer Williams. She knew that was her officer. I can't believe that even if she spoke to Officer Markham, that Officer Markham did not tell her that she needed to turn herself in and they needed to get things straight. She was out for over 2 months until she was arrested on the warrant. I think that her lack of completing the treatment and not reporting shows that she's not amenable to the conditions of probation, as simple things as reporting. In addition to that, she suggests an outpatient program, intensive outpatient. And when she was assessed for treatment, it was determined that she needed long-term treatment to address her issues, not intensive outpatient. So I don't believe that would work either. But I think it's clear over the past few months and this past year that Ms. House can't follow the conditions of probation, and her 2 DUI convictions suggest that she's a danger to the community and a danger to herself. So we'd ask that her probation be revoked.
I would like a chance to speak again, may I, please?
Go ahead.
Your Honor, I understand that I did make a mistake and I know what I did was wrong. I probably should have returned myself in sooner, and I'm sorry that I didn't. I do not have a license. I do not plan on driving. But I would like the court to please, I was offered IOP once and I didn't get to even start that program. Like I said, I have been clean since I was incarcerated in August. I have got 5 months clean under my belt right now. And I do believe, and I don't care to do the home incarceration for my, for the IOP, if you will give me that chance, and I'll pay for it. And I was working full time again. I was able to provide for my kids again. I wasn't, I would really like the opportunity to show you guys that I am not a lost cause, that I can be a productive member of society. If you will please give me that opportunity.
Okay, listen, here's where we are. In February of this past year, your case was put on pretrial diversion. It almost immediately, we had problems and ended up having to void your pretrial diversion. And you begged me for the opportunity to go to rehab, which I agreed to. I'm not going to say that I don't understand why somebody feels like they should leave rehab because they can't get leave to go to a funeral. That happens, and it's unfortunate, and it's understandable that people don't like it. But you don't go to rehab for 7 days and then get travel privileges to go to. It's just how it is. You got yourself there in that situation, and when you get yourself into messes, you got to do what you're supposed to do to get out of those messes, and not just continue to kind of make your own decisions. You had a 1-year sentence. It's you've been on pretrial diversion. You've been on probation. You've gone to rehab on the state's dime. None of those things have mattered. Nobody thinks you're a lost cause. Nobody thinks that you're not worth taking a chance on. None of those are true, but I don't think that it's appropriate to have you remaining on probation under the circumstances of what has happened. You left that rehab, you were in.
But I had contacted another rehab, Isaiah's house, the day that I left that one, to even be able to go back to one.
I understand, but that's not what you were, that doesn't help. That's still not compliant with your probation. Okay?
I understand that, Your Honor.
All right, so listen, this is no longer a dialogue, okay? This is me telling you what my decision is. And my decision is that I'm granting the motion for the Commonwealth, that the Commonwealth has filed. Listen, you're going to get credit for all this time you've been in custody. You're probably pretty well getting ready to get right back out anyway. So, you know, that's the best I can do under the circumstances, but I do not feel like you have followed the terms of your probation. And I don't believe that you're amenable to community supervision at this stage after the water that has passed under the bridge up to now.
So are you saying that I'm going to be going back to rehab?
No,
or-
I'm saying that I'm going to be revoking your probation.
Okay, so I'm going to be doing a county year?
You
I
do
don't understand what I'm
year,
doing.
you have a state year.
I have a state year.
Yes, ma'am.
Okay, so I don't know what that means.
Well, that's what we call an indeterminate sentence. And the reason it's called that is because I can't tell you how long you're going to have to stay in custody to finish serving that sentence. That calculation gets made by somebody else. Okay?
Okay, so the time that I've been in here will count, right?
Yes.
So I have a state year to complete.
Yes, and you're going to get credit for your time in custody on when your pretrial diversion was voided and when your probation is revoked. Okay?
All right, so the 40 days that I've spent and then this 30 that I've been here will count towards it.
I'm not confirming how many days you've spent because I don't know, but the days that you spent will be counted. Okay?
All right, thank you,
All
Your
right.
Honor.
Thank you.
Uh-huh.
Let's go to Miss Guffey.
Judge, I have Officer Ashley Anderson subpoenaed to testify.
Okay, I believe I saw her earlier. Is that all for Miss Officer Williams? Can she go?
It is.
All
Yes,
right.
she may.
Thank you, ma'am. Free to go.
Thank you.
All right, and you said Miss Officer Anderson, correct?
Yes, sir.
Okay. Can you raise your right hand, please, ma'am? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. Ms. Gardner, proceed, please.
Thank you, Judge. Officer Anderson, could you please state your name for the record?
Ashley Anderson.
And you're with probation and parole in Wayne County?
Yes, ma'am.
Did you begin supervising Mindy Guffey in July of 2019?
That's when her initial transfer had been sent to me. She was placed on probation at that time and then transferred to me, and I initially did her intake on August 1st, 2019.
On August 1st, did you give her a date to report?
Yes. When I met with her on August 1st of 2019, she was actually advised of a drug test that day. She was on-site positive for meth and hydrocodone. And upon contacting Officer Alexander out of the Glasgow office, I was advised that the judge would want to set Ms. Guffey up with the SSC and have her follow all recommendations regarding that appointment. Her appointment was given to her for August 13th, 2019 at 9 a.m.
Did she show up?
She did not.
Did you have any contact with her after August 13th?
I did not have any contact with her after that date. When she was a no-call, no-show, we attempted a home visit and left contact notice that she report to the office on 8/20 of 2019 at 8 a.m. and she failed to show for that appointment as well or contact me anytime thereafter.
Did you have any contact with anyone related to Miss Guffey about her whereabouts?
No, ma'am, not after that point.
Okay. So since that time, you've not had any kind of contact with her whatsoever?
No, ma'am.
And she's been deemed an absconder?
Yes, she was at that point.
Okay. I have no further questions.
Okay.
Judge, I've got a couple, Your Honor.
All right, Mr. Berry, go ahead, please.
You had arranged for Ms. Guffey to have an assessment for treatment.
Yes,
Okay. She didn't go to that.
she did not.
What kind of treatment were you looking for? Long-term?
I wasn't looking for treatment specifically. The SSC His job is to determine what kind of treatment is appropriate for the offender, not me.
Well, I understand that, but you
Just-
would have some idea, I would assume, that what kind of treatment she might need, just based on her history.
At that point, I had not had her on my case long enough to know a history of drug use or anything along those lines.
Okay, you knew she was convicted of possession of controlled substance. That's what she was on probation for.
Yes.
Okay. Okay, that's all the questions I have for the officer, Judge.
All right, redirect.
I don't have anything else, Judge.
All right, any proof from the defendant?
Yes, I'd like to call Ms. Guffey.
All right. Hold on just a minute. All right. Ms. Guffey, can you raise your right hand, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God? Hold on, we're muted over there.
Muted.
There we go. All right. Did you say yes?
Yes, I did.
All right, go ahead, please.
Ms. Guffey, you were supposed to get an assessment for drug treatment as part of your probation. Is that correct?
Actually, I'm not even sure. Like she said, I reported one time I dropped dirty and I didn't go back. And I've been high ever since. I came in on Christmas Day and it's the first I've actually been sober. So ARC, Adult Recovery Care, has contacted me and wanted me to come and do rehab there. The lady I spoke to for the intake call said that a bed was actually available, that she would get a hold of somebody, but I haven't got to talk to a lawyer or anything. So, I mean,
Well,
I was high when I went in the office I'm just going to tell you the truth. I was high when I went in the office and I was high when I left, and I really don't even remember it.
okay. Did you report to jail yourself, or you're talking about you got arrested and put in jail?
Christmas Day.
Do what?
I was picked up on Christmas Day.
Okay. So are you telling the court that you want to try long-term treatment?
I mean, if I could go to ARC, I done drug court once before, back in 2010, and I completed it and graduated. If I could go to ARC, then I would love that. If not, I understand what I did, and I ran for a year and a half. So, I mean, that's, you know.
Well, I guess back to my question again, are you saying you want some type of long-term treatment?
Yeah, I would like to go to rehab. I think it would help me better than sitting in jail. I get therapy there. I'll have groups, meetings. I think that would probably be best for me.
Okay. Were you working anywhere since you've been on probation?
No.
Okay. What kind of drugs were you talking about? Meth? Is that what your problem was?
Meth, hydrocodone, Percocet. I'm a drug addict. I could anything.
Okay. Okay. I would.
This is actually the first time I've been clean in a while.
Okay. I'd pass the witness, Judge.
All right. Ms.
Judge,
Gardner?
I don't have any questions.
Okay. Mr. Berry, anything further?
No further testimony, Judge, or evidence. I just.
All right. Yeah, go ahead then. Or well, Ms. Gardner, any rebuttal?
No, sir.
All right, Mr. Berry.
Judge, I don't think Ms. Guffey would be considered a danger to the community or to any kind of victims. She is obviously a hardcore drug user. She was arrested and convicted for possession of meth, hydrocodone, oxycodone. She evidently didn't go get the evaluation she needed to when her probation officer sent her or tried to send her. But I do think she could still be amenable to being supervised in the community with treatment as part of that supervision, a long-term inpatient type of treatment. She mentions ARC. I don't know if that would be available or if there would be other options just as good or better that might be available for. I would ask the court, rather than revoking her at this point, counter time as a sanction to have her assessed while she's in for treatment, and that the court allow her to go attend that treatment if she gets in to a facility, and to allow her to go to that and make that part of her probation to enter and complete that.
Okay, Ms. Gardner?
Gardner, I would ask that Ms. Guffey's probation be revoked. I don't believe that she's amenable to treatment. She was given the opportunity nearly a year and a half ago to be assessed for treatment and address her drug issues. By her own admission today, she spent the past year and a half high under the influence of drugs. I would have great concern for her entering some type of treatment program and leaving. She's shown over the past year and a half she can't follow the conditions of her probation. She has 2 pending Wayne County Circuit Court cases. Those aren't the basis for this motion. They happened right around the same time, but those have yet to be resolved. But I think the fact that she has been running around for a year and a half under the influence shows that she's not only a danger to herself, but a potential danger to others. And the fact that she was given this opportunity a year and a half ago to complete treatment and to be assessed and address her issues shows that she's not willing to obey the conditions of her probation. So I'd ask that she be revoked.
You know, there are oftentimes, this is very rare, but there are oftentimes good explanations for why somebody might have, basically absconded from supervision for 16 months. Quite frankly, being just, too under the influence to want to go to treatment or to cooperate with your officer is not one of those reasons, because that would be everybody's reason. While I agree in principle with the idea that somebody may not necessarily be the most dangerous person in the world to the community when they are addicted to drugs and they're basically just hurting themselves over and over again. By definition, if the way that the law is, if you're supposed to be on probation and you're supposed to be supervised, then it is inherently a danger and a risk if you do not cooperate. Ms. Guffey, I do feel like, you want to better your situation. A lot of people do. I wish that you had wanted to back when everybody else was trying to help you get to that point. And I'm not going to spend a lot of time talking about that. It doesn't make a lot of, that's not a good use of our time to wish things had been different. They are what they are. But at the end of the day, our situation is that, you were put on probation. You did not cooperate basically from the jump. And you have, to paraphrase Ms. Gardner, you've just kind of run around doing whatever you wanted to for 16 months. And that's not conducive to being supervised in the community. I think under the circumstances, the appropriate thing to do is to grant the motion to revoke probation that the Commonwealth has filed, and I will do so. Just similar to the previous case, you are entitled to credit for custody time that you have spent if you have been in custody as a result of this case. So I will, make sure that that is afforded to you. Okay.
All right, thank you, Your Honor.
All right. Thank you. Officer Anderson, if you don't have any other cases, you're free to go.
Thank you, Your Honor.
Thank you in Wayne County.
Thank you.
Judge, can we call Jeffrey Anderson? I've got Sergeant Martin. He's on duty and he's my only witness for that.
Yes. Where is that?
Jeffrey Anderson.
He's in Barron County.
Barron County.
All right.
Judge, I had sent a proposal to Mr. Richardson on this case for a 30-day sanction, and he had sent me an email back saying he would go with a 90-day sanction. And I've not passed it on to Jeffrey yet. I didn't know if he would be interested in that or not.
Let's see.
He's muted.
They're on mute right now, so he'll have a hard time communicating with us. Now, there we go.
Did you hear what I said, Jeffrey?
Do you need him to repeat that?
Yes, sir. Can you repeat that for me?
Yeah. I had sent an offer to the Commonwealth to resolve this on a 30-day sanction. The Commonwealth, the assistant Commonwealth attorney sent me a response back saying that he would go with a 90-day sanction. And I just wanted to know if you wanted to do that, if you wanted to accept that.
Yeah, I do a 90. I accept the 90-day sanction.
Okay. Okay.
Okay, well, that's doable.
Mr. Richardson, he would get credit for the days he's done up till now.
Yes.
Okay. Okay.
And Mr. Berry, just to be sure that we all agree on that, it looks like he was arrested 29 December.
That's correct.
All right, so Mr. Anderson, you'll, on your sanction, you'll get credit back to 29 December, okay?
Yes, sir.
All right, thank you.
Judge, can we release Sergeant Barton?
Sergeant Barton, you're free to go.
Thank y'all.
So, Your Honor,
Yes,
when my 90-day sanction's up, I won't have no hold or nothing on me, will I?
you will not have a hold. You'll need to report to your probation officer the day you get out, unless it's a weekend, and then you report the first business day you get out.
All right, so I got another question. Who is my probation officer? I'm on misdemeanor probation. When I got out in October, they never.
Yeah, he was unsupervised.
Oh, it's unsupervised. All right, my fault. Then no, you don't report to a probation officer. My apologies.
Thank you, sir. You have a good day.
All right, you too. All right. Mr. Bell, are you still on here?
Sure, I am.
Yeah, your client that you have for the Rocket Docket.
Myrna Mills.
Yeah, she got in the meeting a little while ago, and I don't know what kind of device she's using, but she had completely was controlling. I couldn't make any of the stuff work. All I could see was her face. So I put her back in the waiting room so that I could control the meeting.
That's fine. I need to find out what that is.
I do too, so I can try to disable it on other people. It wouldn't let me, I tried to blame Crystal, but she said she didn't do anything. So that's all I have.
Well, now, you know how Crystal is.
I do. But whenever we get ready for her, if you want to communicate with her and ask her just to sit tight, whenever we get ready to do that one, I'll let her back in.
I think Angel's done spoke with her.
Yeah, I couldn't figure out how to, all I could see was actually she must have been using a cell phone. She didn't even have it on her own Visage. All I could see was the ceiling of her room that she was in. And that got old quick, so I put her in the waiting room.
We also have Geronimo Page and Crystal Gent whenever you're ready, Judge. That's Miss Gardner's cases.
Yeah,
I mean, I don't care to wait either. I'm just saying.
One of those is Hart County. I probably just in the interest of trying to be nice to those folks, if we could get their two cases taken care of, I would attempt to do that.
I see Mr. Page.
Yeah, Mr. Page is one of them, and then Miss Petite is another one.
Mr. Page, I believe we've got it worked out, Judge.
Well, what do you think it is?
Judge, we've agreed. I think he's going to stipulate and stand revoked. And if he makes bond in Hart County, agree to revisit the bond in this case.
All right, so are we going to, we need a future court date, don't we?
I believe so.
Mr. Bell, what do you have in mind there? I need to give him a pretrial.
Well, Judge, it's up to whatever pleases the court. If he makes it out of Hart County, I'm going to talk to him about maybe some type of rehab situation if he's interested. So whatever you want to give us is fine, Judge. I don't.
All right, let's do February 22nd. That's 4 weeks.
That's fine, Judge. That'd be at 1:30.
Yeah.
Could you repeat that date again, Judge? I'm sorry.
Huh?
The date, I missed it. I wasn't paying attention.
February 22.
Okay, thanks.
And as we move closer to that, we'll send the Hart County Jail a link or an invitation, whatever the phrase is, so that they can be present. Okay?
John, if you get out over there, you call and let me know, okay?
All right, yes, sir.
All right.
Are you all ready to do Amber Poteet?
Judge, Josh is telling me we've got a deal worked out in her case. He sent the paperwork, but he's not got anything back yet. So that's mainly what we're waiting on. We'll see.
I just had a question if I could ask real quick.
Okay.
Right here it says, so y'all know I got this case in Hart County, right? The theft of deception, right?
I knew you had a case in Park County. I didn't know about that one, but.
Yeah, I have a case. That's why I'm being held here. And it says I may be subject to greater enhancement penalties if found guilty and convicted in any further criminal offenses. And I just.
Judge, can I get on the phone with her real fast and talk to her and you move on to something else real fast? Let me explain that to her. Okay.
Yeah, I understand what her question is, and I think it's probably inapposite to our current circumstances, but it might be better for you to explain that to her. All right, we'll come back then.
Your Honor, do you need Mr. Brent? Rondell Brent?
He was the one that we had yesterday that Johnny and I did the agreed order.
Yeah, we don't need him today.
Okay.
If he's still in custody, I thought we had agreed for him to get out. I don't know if he's being held. I didn't think he was being held on anything else.
Yeah, he's being held on Hart County.
Oh, okay.
But we're working on that.
Okay. All right.
Yeah, I signed the order that actually we sent a commitment order right over there to Hart County, so they knew, and then because I didn't know if your all's order would come in yesterday or today, but it came in yesterday, so I signed it yesterday.
Okay. Are you ready, Johnny, on Crystal Gent?
I'm willing to attempt it. I haven't spoke with Crystal yet because I just got that around lunchtime, but
You want to talk to her and then just call the jail, talk to her?
Honey will let you call her.
Okay, yeah, I'll do that. We can do we can do Marna if you want to, Judge, or we can wait. It's up to where.
Well, that's fine, and then we can, that way I can take care of her, and then you can call and talk to Miss Gent, right?
Yes, sir.
All right. Well, allow me to find my waiting room and let her in. This is Miss Mills. I've got her file over here. Yeah, it's a F. Yeah.
Jay don't see Bonnie, let us talk to her.
Bonnie's pretty mean, but if you ask her nice, she'll let you.
I always ask nice, Judge. I've got a strong reputation in the community of being a super nice guy.
Which circles in particular are you referring to?
They're just mainly my circle, you know, out.
Yeah, yeah. So Miss Mills, are you there? I don't see you.
Yes, I am. Oh, there we go.
We need to get your camera. There we go.
There we go.
Now we're talking. All right. Hey, listen, we need to talk through and figure out exactly what's happening here. I've got some paperwork, and have you looked at that paperwork?
I did.
All right. It's just that you, I believe this is the case we discussed earlier, where you were not able to sign it because just something about the formatting or whatever on your phone, you couldn't electronically sign it and send it back.
Yeah, it won't let me, it's saying it's locked for editing.
All right.
So it won't let me, I mean, I can open it and I can view it, but it won't let me sign it.
Okay.
And I don't have a printer.
If you had been able to do that, would you have signed it?
Yes.
All right. Let me ask you to raise your right hand and we'll go through this here. Okay. Do you swear or affirm that you will tell me the truth, so help you God?
Yes.
All right. Miss Mills, first off, I've got hey, Johnny.
Yes, sir.
Did you have a motion to enter a guilty plea? I guess that was something that you were going to have her sign when you saw her, but I don't have that. Have one?
No, I do not, Judge. I've got the Commonwealth's offer. I've got the information. I've got a waiver of rights. Agreed order granting pretrial diversion, but I do not have a motion to enter guilty plea.
Well, do you believe that you and Miss Mills talked about that and you just don't have a signed one?
Well, I mean, in essence, have we talked about our rights? Yes, but I mean, I can get that together and try to forward it to her, Judge, if you want me to real quick.
Well, that's fine with me. I need a motion, before we're
Absolutely.
You know what I'm saying?
Yes, sir, I do. We just overlooked it, I guess, when these informations and things, it's more paperwork and a diversion added to it. I guess I just overlooked the motion to enter guilty plea.
Oh, right. There's multiple additional documents on one of these than there normally is. Why don't we do this? Why don't we, whatever method you've used to send those other documents to her, why don't you send that to her and let her look over it and talk to you? She can talk to you if she needs to, whatever needs to happen. And I can actually put her back in the waiting room. And then that way, if she has to hang up, if this is a phone that she's on and she needs to use it to call you, and then all she has to do is try to log back in. If I remove her, she can't get back in, but if I put her in the waiting room, she can.
That's fine, Judge, and I'll get that together and call her real quick.
Yeah, and then you all just
Yes.
tell me whenever. I don't have.
You want me to send a
going
copy
through
of
with
that?
this other.
Be fine.
I don't have a problem going through with this other stuff without her signature, because I'm going to ask her about it anyway. And there isn't any difference in her giving me the, agreement and letting me just write her name on it and say that she'll be under oath. Isn't any difference in me doing it or her doing it for you. So I don't have a problem with that, but I do want to sign the, motion to enter.
I'm sending a PDF of the motion to enter guilty plea to Johnny's office right now.
All right.
All right.
We'll get that
So
together.
I had something that said something about a guilty plea in the paperwork they sent me, I thought, but maybe I misunderstood.
Yeah, you don't have the one document that we're talking about. I'm gonna tell you what I'm gonna do. I'm gonna let you, I'm gonna pop you back into that waiting room. And then if you have to hang up and call Johnny on your device, that's fine. But then you ought to be able to log back in and you might be in the waiting room for a minute, so don't panic. We'll get you. Okay?
Okay.
All right, thanks. No, I've just got to put in waiting room. All right, very good. Okay, let's see. Let's move on to somebody else we might have down there.
Reason I'm back.
Yeah, do we need to do Amber Petit?
Judge, they said that she told me when I got off the phone with her that they were sending the plea documents, but I've still not received them either via email or fax.
She just gave them the book and to send to you.
They've got it. If it's coming from Mumfordville, it's got to go over a river and everything. It's going to take a little more time, you know.
True. Okay.
All right. Well, let me know when you get it and we'll come back to her. But we're going to need that before we go forward.
Will do.
All right, Miss Gardner or Mr. Richardson, either one of you. Who you want to do next?
I think
I don't have
like-
anything.
I just have Amber Petit and that's it. That's all I got.
Who got Donald Harrison?
That's John's case and it's mine too, so.
Let me talk to John real quick because John, I think, didn't think he had anything on.
Well, it was just something that you all told me yesterday. You thought you had a plea worked out, right?
Yeah, we do.
So, I mean, do you have
I'll
all
just
the
stand
paperwork?
in.
Yeah, I sent the paperwork to your office.
Well, maybe you did. All I have is a motion to enter a guilty plea. I don't have the rest of, oh, never mind. I made an inadvertent faux pas. I do in fact have it. Mr. Harrison, you ready to roll?
Yes, sir.
All right, bud. Raise your right hand. Do you swear or affirm that you'll tell me the truth, so help you God?
Yes, sir.
All right. Fair enough, Mr. Harrison. I'm looking at a motion to enter a guilty plea. I'm going to try to show that to you. Does that look familiar?
Yes, sir.
And here's the signature page. Does that look like your signature?
Yes, sir.
All right. Now, did you read this before you signed it?
Yes, I did.
Did you have time, if you needed to ask any questions, to ask those questions?
Yes, sir.
Are you satisfied that you've been able to talk to your lawyer in a sufficient degree that you're making an informed decision here?
Yes, sir.
All right. Do you believe that you're being made or forced into an agreement by me or by anybody else?
No, sir.
All right. Are you in fact telling me today that you have an agreement and that you voluntarily and of your own free will wish to enter it?
Yes, sir.
Okay, Mr. Harrison, do you understand that you have the following rights? You have the right not to incriminate yourself, the right to a speedy and public trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses, the right to put evidence on in your own defense, and the right to appeal.
Yes, sir.
All right. Do you also understand that if you plead guilty and I accept your plea, you waive each of those rights?
Yes, I do.
All right. Mr. Harrison, do you believe that your judgment is impaired today for any reason?
No, sir.
All right. Did you have any difficulty understanding anything in the motion or in the Commonwealth's offer?
No, sir.
All right. Did you have adequate time to discuss the case and the evidence and your options with your attorney?
Yes, I did.
All right. Mr. Harrison, I'm also looking at the motion, or I'm sorry, the Commonwealth's offer. Is that your signature?
Yes, sir.
All right. This is the front page of that. Does that look familiar?
Yes, sir.
All right. We're going to talk about what it says too, okay?
Yes, sir.
Your charges and the recommendations of the Commonwealth in each instance are as follows. Count 1, possession of a controlled substance, first degree, third or greater offense. That is a felony, Class D. The Commonwealth would recommend a sentence of 1 year. Fleeing or evading police in the first degree, that's count 2. That's a Class D felony. The Commonwealth recommends a sentence of 1 year. Theft under 500, that's a misdemeanor. Commonwealth recommends a 12-month sentence. Drug paraphernalia, that is an A misdemeanor. The Commonwealth recommends a 12-month sentence. The 1 year, 12 months, and 12 months all run concurrently or at the same time for a total of 1 year. The Commonwealth also says there may be restitution. Generally, if that's not agreed upon at the outset, then I'll give them like a 30-day window after today to either file a request for restitution or to have your attorney talk to you about an amount. Okay?
Okay.
All right. So that may be a possibility moving forward, but it isn't a possibility forever. They'll just have a 30-day window to do that. The the Commonwealth opposes probation and would oppose if you asked shock probation. Do you understand that?
I think so.
All right, ask me what you,
But I mean they're against it because I said something to my lawyer and he said, well, we tried in 30 days. Just because they
All
oppose
right,
it,
yeah.
I mean, I won't get it, right?
no, they are saying that they are against it. That doesn't mean that you can't ask for it.
Okay,
It doesn't mean that I may not give it to you, but
right.
it just means that
They're up against it.
no, and nothing about the plea should be based on you thinking that they're going to agree for you to get probated,
Right.
because they're not going to agree.
Yeah.
All right. So as of right now, would you agree with me that nobody has promised you that you will get probation?
Yes, I agree.
All right. Your attorney has told you that you can ask for shock probation,
Yeah.
but he hadn't promised you, has he, that I'm going to grant it or that the Commonwealth will agree to it, either one, right?
No guarantees.
All right. Other than what you and I have just discussed, has anybody promised you or threatened you or told you anything to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty of your own free will?
Yes, sir.
Mr. Harrison, are you acknowledging that on September 19th, 2019 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
Are you acknowledging to me that at that same time and place, you unlawfully took or exercised control over the movable property of Walmart with the intent to deprive the store thereof, and the value of such merchandise was under $500?
Yes, sir.
All right. And finally, are you acknowledging that at that same time and place, you committed the offense of fleeing or evading in the first degree in a motor vehicle? When you were operating a motor vehicle, you had the intent to elude or flee, and you knowingly or wantonly disobeyed a direction to stop your motor vehicle given by a peace officer. And by that, your conduct, you caused or created a substantial risk of serious physical injury to any person, death to a person, or serious damage to property.
Yes, sir.
All right, Mr. Harrison, I will accept your plea of guilty here today. Josh, have you all talked about what you want to do? Does he want to?
Yeah, wait, PSI.
All right.
I do have a question, Judge. Is that fleeing and evading, will it be considered a violent charge?
No, sir.
Okay. I didn't think so, but the way you said death and all that, it's kind of spooked me a little bit.
Well, it didn't result in it. It just creates a risk of it. That's different. Yeah. All right, Mr. Harrison, I'm going to accept your plea. I'm going to accept your waiver of a PSI. We'll go ahead and sentence you today. The agreement was 1 year. I will waive your fines and your court costs. We will preserve for 30 days after the entry of your judgment the Commonwealth's ability to ask for restitution if they believe that there is any. But like I said, that's not open-ended. That's just a period of 30 days, okay?
The restitution would be like if I actually took something, because they recovered the property, so would I still have to pay for it?
Yeah, they probably not. I mean, a lot of times they just put that in there because they need to check and see if the property was recovered or whatever. Or, sometimes when somebody's trying to steal something, they might damage, something or whatever. So it's just in case. But I mean, most of the time, if it's real substantial possibility, they already know,
Yes, sir.
Okay.
And then my last question would be, is that as far as like the time spent until I got revoked, I'll get credit for those days too, right?
You are, yes.
Okay, thank you.
Yeah, you get credit for your, pre-sentence custody on this case, as well as, anything that would happen between now and like your judgment getting entered, which probably it'll just be a day or two anyway, but.
Okay, all right, thank you.
Okay, all right, thank you. Did you give me a docket? I just don't have one.
Judge, what was the case number on that?
What was the case number?
Yes, sir. I don't have it on the docket.
Yeah, it was 20-CR- look it up yourself. No, I'm just kidding. It was
Sir.
20 CR 392.
Thank you, sir.
We added it on from, he had a pretrial yesterday and they kind of hammered out a deal, but they didn't have the paperwork done. So we just added it on kind of last minute.
Works for me. Thank you.
All right. All right. Well, y'all let me know when Johnny comes back. I'm gonna go over here and do some, some Tai Chi, get my mind right. You know what I mean?
What's going on? Can y'all hear me?
We hear you, Johnny.
Well, we're ready to go, Risa. Both cases.
Good deal. Do we have an agreement and gent?
Yes. Well, yeah, on what we talked about. I told her, it's kind of, we hadn't got to really iron it out that great, but we can go through it.
Okay.
Fix whatever we need to do.
All right.
All right. Has Candy put the drug court workers to build railroads, ties and stuff?
Move mountains, Johnny Bell.
Move mountains.
Yes.
I got one to move out there. Can you send them out there to help me out?
Price is right.
I ain't got no money.
Then you ain't getting no help.
Trump took it all.
So you go ahead and get her on the waiting list for KRC.
I guess, but I want to be out of Somerset. Can we do that?
You can, but I will tell you that that'll be a longer wait than you think. First available, I've been getting about 2 weeks. If I specify, it could be 6 to 8.
Well, let's see how it works out here in a minute. We'll go from there.
Okay.
Right now, next meeting, she would know. She knows a lot more about the state stuff than I do. Yeah, all right. What is the count of years?
After all the good time, everything do about 7 months, 11 days. I got 4.5 now, I have so much, a total of 5.5.
I don't care if they stick me back in drug court or what. Do something.
Allen County ain't having drug court.
Really?
Yeah, I thought for shot for drug court. I said, the drug court has been postponed right now due to the COVID. Go back. Go back. Thank you.
Is there any way I can talk to Genevieve again? Would you like to call? AM.
This morning or, yeah, okay.
I checked it, but I can't find it now.
All right, y'all got anything ready to go?
I think Johnny said we're ready.
Yes, sir.
Okay.
On Martin Mills or Crystal Gent, either one. Martin would probably be the easiest of the two, Judge.
Well, then I will go to my waiting room and bring her back in here.
And Risa, you know, we talked about a different state. She had advised me that it'd probably be Virginia.
Okay, we'll just address that when it becomes an issue.
Okay.
All right, Miss Mills, I don't have audio or video on you. All right, now I have audio.
You should have video.
I do now.
Okay. It showed on my end, but I guess
Yeah.
I had that paperwork up, so it didn't.
Yeah, okay. So let me go ahead. I can't remember if we ever got to the point where I put you under oath, so let me do that. Do you
Yes.
swear or affirm that you will tell me the truth, so help you God?
I do.
All right, thank you. You'll bear with me just a minute. I'm gonna get Mr. Bell up here too, just so that if there's any questions, he'll be there. All right. So Ms. Mills, when we started a minute ago, we were talking about the various documents, and in this kind of case, there are a lot of them. The one thing that I think you paused so that you and Mr. Bell could discuss was the document that is called a motion to enter a guilty plea, right?
Correct.
All right. And did you and him just talk about that?
We did.
All right. Did he explain that to you thoroughly?
He did.
All right. And in addition to that, did you have the chance to read over it yourself?
Mhm.
Okay. If you were, and I don't remember whether you were going to sign one digitally or, virtually, or whether he was going to sign your name for you or what. I don't remember what we talked about doing. How are we going to do that?
He is supposed to sign my name.
Okay. All right.
for
Did you
you or
authorize
something.
him? Did you authorize him to sign your name?
Yes, I do.
And in doing that, do you acknowledge that you understand what's contained in the motion?
I do.
Specifically, do you understand the following, that you have the right not to incriminate yourself? You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine witnesses. You have the right to put evidence on in your own defense, and you have the right to appeal. You understand those?
I do.
Do you understand that you would waive each of those by pleading guilty?
I do.
Okay. Ms. Mills, do you feel like you're under the influence of anything today?
No.
Is your judgment impaired for any reason today?
No.
All right. Have you had all the time that you feel like you need to decide how to proceed and to discuss the matter with your attorney?
Yeah.
All right. Let me move on then to the Commonwealth's written plea offer. But before I do that, let me also say there is a document that's called a waiver. It's right here. And if I understand correctly, you looked over that and discussed that with Mr. Bell as well, correct?
I did.
All right. And if you're giving me authorization, I'm going to write your name on there as if you signed it. Is that what you're doing?
Yes.
All right.
Also,
That is, okay. That brings us to the offer from the Commonwealth, and that's right here. Again, that I believe you have seen that as well. It's got
Yes.
a signature line on it that Mr. Bell has signed, Ms. Gardner has signed, and then right here would be where you sign. Are you telling me that if you had this document in front of you, you would sign it?
Yes, sir.
Do you authorize me to put your name on it as if you signed it?
Yes, sir.
The heck? All right, ma'am, let's talk about what that contains. Your charges are possession of a controlled substance, first degree, first offense, possession of drug paraphernalia. The Commonwealth has agreed to recommend as follows. If you plead guilty to possession of a controlled substance, first degree, first offense, the Commonwealth would recommend a 1-year sentence. If you plead guilty to possession of drug paraphernalia, the Commonwealth would recommend a 12-month sentence. Those sentences would run concurrently for a total of 1 year. They would also carry a possible fine up to $1,500 and court costs. The Commonwealth agrees that instead of sentencing you to serve 1 year, that you could be placed on pretrial diversion under supervision of probation and parole for a period of 2 years on the condition that you get a substance abuse assessment and that you comply with any recommendations that may come from that assessment. You understand that?
Yes, sir.
All right. And is that what you have agreed to?
Yes, sir.
Other than that promise from the Commonwealth to make those recommendations, have you been promised anything else by the Commonwealth to try to get you to plead guilty?
No, sir.
Okay. Has anybody threatened you to try to make you plead guilty?
No.
Are you pleading guilty voluntarily?
Yes, sir.
Are you acknowledging that on October 12th, 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right, ma'am. I'm going to accept your guilty plea today as a result of this conversation that we are having, and I'm going to move on to this agreed order. Last but not least, the Commonwealth has prepared an agreed order setting out your terms of pretrial diversion. Are you familiar with that?
Yes, sir.
Did you get the chance to look that over?
I have.
All right. And if you were here today, would you be signing it right here?
I would.
Okay. With your permission, I will sign I'm not pretending to be you. I'm writing your name.
Right.
You know, with your
Yes, sir.
permission, I will sign your name on that. Is that all right?
Yes.
All right, ma'am. In that document, it discusses the terms of your pretrial diversion, and you'll get a copy of this. I suppose what I better do before we finish up here is get your address to be sure that this goes to you, directly. It'll go to Mr. Bell, but I'd like to send a copy directly to you too. Can you tell me your address?
Well, in Kentucky, I'm using my daughter's address for mail.
Okay.
If I'm allowed to go to Virginia, then I will be at a girlfriend of mine.
Well, tell me your Kentucky address for now.
497 Millerfield Road, all one word,
Okay.
Columbia, Kentucky, 42728.
And Judge, would you care if I could put on the record just a little bit about Mr. Bell and I have discussed about treatment in another state?
Yeah. Let me finish.
Oh, okay.
I just need to go, make sure that I go over this pretrial diversion order with her, which I've already done.
I apologize. I thought
No,
you were
that's
done.
fine. That's fine. I just need her to know, I always feel a little reluctant to just sign something that has blanks in it without telling somebody what I'm putting in those blanks. And this one has court costs to the Barron Circuit Clerk on or before blank. Well, what I normally do is give people 6 months to pay that. So your court costs will be due within 180 days, okay?
Okay, now question, because if I'm reprimanded to treatment and their recommendation is 6 months, then I'm not going to be able to work for 6 months.
That is true.
So that was my only issue with.
If that's the case, your probate, I'll know that you've gone to treatment if that's the case. I'm not gonna jack you up for not paying $165 if you're in treatment.
Right. Okay. I just want to make sure that that's able to be changed or whatever if need be.
It is. I'm not gonna fine you because to me, the fine is part of a sentence, and the whole idea behind pretrial diversion is that you don't get actually sentenced, but instead you get the chance to
get your life back together.
Show that you can behave and that you can get things straightened out, and then you actually never get sentenced. And the beauty of pretrial diversion is that if you complete it, your charges actually get dismissed, so you won't have a conviction. As of now, you've got a conviction in the sense that you've pled guilty, but your sentencing is put off more or less indefinitely. And after 2 years, if nothing has happened and everything's fine, then you never get sentenced at all. We go back and dismiss the pretrial or the plea. And then, if you wait 60 days, you can get it expunged and nobody will ever even be able to see it. Okay.
Okay.
So, those are all pretty good advantages that sometimes I think people tend to lose sight of how good of an advantage that is. So I try to explain it to people that, something happened and, you're going to kind of have to answer for it and work your way back out of it and all that. But you do get a pretty big prize at the end if you comply, because the whole felony goes away. Okay. All right. All right. That's all I have then. I'm going to go ahead and sign off on this. I'm going to assume that Columbia it's not one of those weird post office box scenarios where you're in an actual different county. You're actually in Adair County, right?
My daughter, yes, she's in Adair
Yeah.
County.
Yeah.
Her address
Well, you
is in
know, occasionally you'll get one of those that it says a city, but it's really in a different county and all that nonsense. So I just wanted to be sure. All right.
Yeah, I had stayed in Canmore, and one of the ladies I stayed with in Canmore had her physical address was Canmore, but her mail went to Hardyville or something like that. It was messed up.
Yeah, there's all kind of weird things like that. I mean, you can live in Barron
Yeah.
County and get serviced out of the Horse Cave
Right.
post office and stuff like that. So I just wanted to be sure.
No,
All right.
she's in Adair County.
All right, Miss Gardner, go ahead.
Judge, this is kind of a unique situation. Ms. Mills has expressed an interest in going to an out-of-state treatment program. Part of the deal is for her to be assessed. I don't think she has anything firmed up yet, but what Mr. Bell and I have agreed to do is if she's found an out-of-state program that, you know, we can work on the supervision issue and maybe amend the terms of the diversion for her to do that, depending on what the program is.
Okay.
And I mean, as far as that goes, I can be assessed here. And I mean, if your people assess me and say they want, you know, these certain things met on a treatment center out of state, I'm okay with that. My thing is I have nowhere to live here. I can go to Virginia and stay with a girlfriend of mine and at least have a steady home and know where my next meal is coming from.
I just wanted to put on the record that the Commonwealth is willing to discuss with our attorney and figure something out for Ms. Mills. It satisfies both, you know, our desire for her to get treatment and then to address her current personal situation.
All right. Yeah, I mean, listen, the whole upshot of it is that, I mean, nobody wants to stand in your way of things getting better. And if you know, if things can work out that way, then Ms. Gardner just wanting, I think, to let me know that there is a possibility here that we can, you know, that if you find an out of county or out of state place that suits and it's better than any other alternative, the Commonwealth's going to try to make sure they don't get in your way. Okay.
And Your Honor, just quickly, you know, not to belittle the point, you know, I appreciate the Commonwealth working with us, and you know, I know Ms. Mills does, but she's also in a very, very, not to go into a lot of details, but in a very
domestic
sort of
violence.
dangerous, yeah, she's in a very volatile relationship, a lot of domestic violence, and that's another reason she is trying to remove herself from this area and away from that threat.
Understood.
Which is neither here nor there, except I just wanted the court to understand her situation.
Yeah, I mean, these things are sometimes a little bit more complex than they might look to me when all I'm seeing is paperwork, you know?
Yes, sir.
So I appreciate that. Okay.
Yes, sir.
All right. Ms. Mills, I don't really have anything else for you, but we have Officer Bennett from Probation and Parole, and he's going to tell you what needs to happen, you know, in terms of moving forward with this thing. So Officer Bennett, do your thing. Okay.
Thank you, Your Honor. Ms. Mills, I will need you to report to Probation and Parole in the morning by 9 a.m. Do you have the address for Glasgow Probation and Parole?
I don't.
It is 100B Reynolds Road, Glasgow, Kentucky.
You said B Reynolds Road?
100B Reynolds Road, Glasgow, Kentucky.
Are you going to have a ride, Myrna?
I'll have a girl drive me over there tonight and I'll figure something out.
If worse comes to worse and you cannot get over there, make sure you call our office. And
yeah, give her your number, Seth, will you? Or the
yeah,
you would need to call.
Yeah, my cell phone number is 270-791-8255. 4940. And that's my state cell phone, so I'll be on it if you need anything. If something happens and you can't make it.
Yeah, because the only way that right now, the only person I have that will take me anywhere works first shift. So she doesn't even get off work until 3:30 in the afternoon, Eastern time.
That's understandable. Just give us a call. We'll get everything situated for you. Okay.
Okay.
Thank you.
Yeah, just, hey, listen, the big key here is to stay in contact with them. I mean, if something happens and you can't get over there, don't just blow it off, because they, you know, now that they've told you that you need to make contact with them, they'll expect that to happen. So just stay in contact. You know, communication helps to avoid a lot of these problems that we see. Okay.
Okay.
All right. Do you have any questions of your own, Ms. Mills?
No.
All right. Then I'm done, I suppose. Mr. Bell, do you have anything?
No, Your Honor. If you have trouble,
All right.
Mark, just call office, okay?
All right, Ms. Mills, I'm going to excuse you from the meeting, okay?
All right. Thank you, sir.
Good luck, ma'am.
Thank you.
Judge, I've emailed you plea agreement on Amber Petit.
Yep, got it right here. Except I need Miss Petit to, yeah, there we go. Now we're talking. Miss Petit, can you raise your right hand? That one. Do you swear or affirm that you'll tell me the truth, so help you God?
Yes, sir.
All right. I have in front of me a motion to enter a guilty plea. It looks, wait, I want to get where I can see. All right. This is it. Yeah, there you go. These look like they're pretty much the same. Did you sign that right there?
Perfect, sir. Oh, that's Mills.
Oh, that's the wrong one, isn't it? You brought me the, oh no. Getting all my papers mixed up. That was the last case. This is the one I'm intending to show you.
Yes, sir.
All right. And did you look over that pretty thoroughly?
Yeah.
Before you signed it?
Yes, sir.
You understand everything that's contained in there?
Yeah.
Did you have the opportunity to talk to Mr. Spears about anything that you might not have understood?
Yes, sir.
All right. Let's start with this. Do you realize that you have the right not to incriminate yourself, and you waive that if you plead guilty?
Yes, sir.
You have the right to a speedy and public trial by a jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. You could confront and cross-examine witnesses, and you could put evidence on in your own defense. Do you understand that you waive each of those rights if you plead guilty?
Yes, sir.
You have the right to appeal. Do you understand that you waive that right if you plead guilty?
Yep. Yes, sir.
All right. Ms. Petit, do you feel like you're under the influence of anything right now?
No.
You feel like your judgment is otherwise impaired for any reason right now?
Nope.
All right. Have you had all the time you need to go over these documents and to think about how you want to proceed?
Yes, sir.
All right. Has anybody threatened you in an effort to get you to plead guilty?
No, sir.
All right. The Commonwealth has made some recommendations or promised you that they would make these recommendations, and that, yeah. So you've gone over that document as well.
Yes, sir.
Other than the recommendations on that document, have you been promised anything to try to get you to plead guilty?
No, sir.
All right. I want to make sure we understand each other on the recommendation. So count one is possession of a controlled substance, first degree, second offense. On a guilty plea, the Commonwealth's recommending a 3-year sentence. Count 3 is tampering with physical evidence, a Class D felony, and on a guilty plea, the Commonwealth's recommending a 3-year sentence. Count 4 is drug paraphernalia. That's a misdemeanor. On a guilty plea, the Commonwealth's recommending a 12-month sentence. Count 2 is a co-defendant's charge, so that doesn't apply to you. The total recommended sentence would be 3 years on count 1, 3 years on count 3, 12 months on count 4, all to run concurrently for a total of 3 years. The Commonwealth agrees to probate that sentence for a period of 3 years under supervision of probation and parole. and you would get a substance abuse assessment and comply with any recommendations that may come from that assessment, right?
Yes, sir.
All right. Is that what you understood the agreement to be?
Yes.
Do you feel like I put anything in there that you didn't agree to?
No.
Do you feel like there was something major that I left out?
No.
All right. Are you telling me here today that you wish to enter a plea of guilty voluntarily and of your own free will?
Yes, sir.
Ms. Poteet, are you acknowledging to me that on September the 8th, 2019 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
Are you also acknowledging that at that same time and place, you committed the offense of tampering with physical evidence when you destroyed, concealed, removed, or altered physical evidence that you believed could be produced in a proceeding that was pending against you or that was about to be instituted against you with the intent to impair the availability of the evidence?
Yes, sir.
All right. Then I am going to accept your guilty plea here today. Now, correct me if I'm wrong, but you're over there. Did I understand that you've got a pending case that you hadn't made bond on yet?
I've not made bond on yet. No, sir.
All right. So if you want me to, I can go ahead and sentence you today and in all likelihood, unless something crazy happens in the next 5 minutes, grant your request for probation. However, that would not result in, you being released. I mean, you understand that until you've dealt with whatever your situation is in Hart County.
So are you saying you can go ahead and sentence me, and whenever I bail or go to court here, I'm just get out and come with you?
Yeah, I'm saying that I can sentence you and I can go ahead and put you on probation. But then if in the future, as I assume will happen, you get out of custody, you'll report to probation and parole, as soon as you get out.
Yes, sir.
All right. All right. Is that what you want?
Yes, sir.
Okay. Well, then, having accepted your guilty plea, I will sentence you in accordance with the plea offer, which is 3 years on count 1, 3 on count 3, 12 months on count 4, all to run concurrently for a total of 3 years, and accept your waiver of a separate sentencing proceeding, and I'll sentence you today to that. Okay?
All right. Question real quick. Whenever they sentence me here in Hart County, will they run that concurrent with yours? Will I take how will that work?
That will be up to Hart County because they're, second in line.
Okay. All right.
I mean, not as a general observation, but I mean, in terms of your two cases, this one is, was first. So it'll be up to them whether they, whatever plea offer they make you or whatever happens to, whether you happen to be sentenced concurrently to this one or consecutively to this one.
Okay. Thank you.
All right. Do you have any questions?
No, sir. You have a good day.
All right. Listen, one thing, let's see, let's get Seth back on here.
Yeah.
Seth, we're following all that, weren't you? Right now she's in custody and isn't going to be getting out at any, ascertainable time, but at some point in the future she will be. So tell her what you want to tell her.
Right. Thank you, Your Honor. Ms. Petit, just make sure if you are released at any time that you report to Barron County Probation and Parole first.
Yes, sir.
If nothing else, get our number from the jail or something and make sure you make contact, okay?
Okay.
Right. Thank you.
Yeah. If you have to report to this office initially, but I mean, if you're going to be living in Hart County or whatever, you don't have to be supervised out of this office, but you have to go through here, and start that process. Okay.
Thank you, sir.
All right. See you.
Okay.
Could we call Crystal Gent, Judge?
Yep. All right, Ms. Gardner.
Judge, this is our motion to void. Candy has said that she's able to arrange a treatment program at RKC for her, and we'd be willing to do that in lieu of voiding. There is an issue. She does have 2 new indictments.
Yeah, I was gonna ask you about that.
Yeah, I didn't know anything about that either.
Yeah, it just happened.
I think basically what we need to do is Candy can arrange that date, bed date for her if she's interested in doing that. And maybe we could add her to the docket this Monday for an arraignment. And I think we just need to maybe put a pretrial out 6 months, and that way there's no issues with her going to treatment.
Yeah, I think she'll be on the docket Monday because all of those indictments just got processed today, I think.
There's 3.
Yeah, I see them on there. There's 2.
2.
Mhm.
What is the indictments on?
Well, I can look those up for you, Crystal.
Okay.
Get you that information.
All right.
Johnny, are you going to be doing those or?
I'm not certain. I'll try to see kind of what Commonwealth's got on their mind. If it's not too wild and woolly, we'll try to get through it somewhere or another. I'd like to help Crystal if I could.
I honestly would prefer for her to get a treatment and see how she does, because both cases involve co-defendants, and I don't want to try to quickly resolve anything in these 2 new cases.
Well,
Better just get a treatment.
That's fair, Judge. That's what if nothing, either resolve it quickly and or lay it out. Let Crystal sort of be the the guide of her own ship, so to speak.
The captain of her own ship.
Destiny. Your Honor, the only issue, and I brought this up, Teresa, a little bit, but I will say up front, we don't have an agreement on this or anything like that. I had got involved in this case due to the fact that Ms. Gent's sister and brother-in-law, I thought it was her dad, but I found out today that was her family. It was. They had her up in Somerset for 9 months, and she done IOP. She didn't have any issues, any problems, anything at all. She came back down here, and as is the case in most situations, fell back in with the same crowd, and we ended up right back here where we're at. She has an autistic child that his family is taking care of now. She had asked me about going to treatment in Somerset, but Miss Browning advised me that it would be a lot longer wait for her. And then I don't know if there would be any kind of objections to, I think she's been in jail almost 2 months. Is that right, Crystal?
Right, 50 days today.
And I don't know if there'd be any objection to allowing her maybe to get out on an ankle monitor or something pending this, if she went to Somerset on strict home incarceration out of this community.
Right.
And as I said, I'm not trying to say that anybody agreed to any of this or start any kind of a ruckus whatsoever. I'm just bringing it up for discussion and see kind of where we're at on that situation.
I would say that I'm not inclined to agree to that right now.
Yeah, can I just dive in here and say that we had almost, when she went to drug court, it was just from the jump, it was nothing, we couldn't get her to do anything. And Candy was on the phone with me 2 or 3 different times at midnight, I ain't awake at midnight, thank God, but it was, 10 or 11 o'clock, with issues. Cave City cops were out with her and, doing different things. And I would prefer to at the very least defer any conversation about that until we can get her arraigned on Monday on the new case, and then kind of, go from there. But I understand that the situation might be a little bit different. And you're saying Somerset, which would at least alleviate the problem of her getting trouble in Cave City. But, trouble has a way of finding you if you don't try real hard to not let it. So
can I say something?
Issues here.
I got away from the issue was my ex-boyfriend. I got away from him. He was the main reason why I kept getting in trouble. But I had moved.
Don't discount your own agency in that.
I blame myself too. You know what I'm saying?
Yeah. Okay.
And that's the reason I removed myself.
And Crystal, I believe, we're in good shape right now, to be honest. We seem to be moving your boat in the right direction. Let's not look a gift horse in the mouth. I understand, you know, we just got till Monday. When you get an arraignment, that gives us some time to, you know, see where Miss Browning is with getting you into a treatment facility, and maybe we can facilitate these things, and everything might be, you know, some might be shining bright Monday that, you know, a lot brighter, you know, then than it is today.
Johnny, I can't put her on the waiting list till after Monday. State law is she can have nothing on CourtNet with a 6-month pending case. So I can't even do it till Monday after court when CourtNet removes that date. That's not me. That's the state law, not me.
Okay.
Is there any way possible that I could try the drug court again? Give me one more chance, because I'm willing to do it.
No, we can't do that. We're gonna have to have rehab. There's no other way. We couldn't watch you in the 3 or 4 weeks we had you because you were always in trouble. And with COVID, I can't risk that.
Okay, that's fair.
I mean, I just want you to get help. We're not trying to put you in jail. We want you to go to jail and get your help.
I want to get help. I want to get help.
I just, like I said,
I think we'll have to get her on a waiting list,
Monday.
Court Monday. You know, it'll be at 10 o'clock. So, you know, Candy may be able to give us an idea even by the end of the day on Monday, what we're looking at.
Okay.
And Judge, you know, the Somerset thing, you know, mainly sometimes it seems, you know, I've talked to her family up there. They're pretty stringent on her staying straight. And I believe, you know, sometimes to answer the family and loved ones and things, you know, poses a part of your personality that makes you want to try hard not to let them down or shame yourself. You know, it just seemed like they were really willing to work hard to try and help her get straight and give her somebody to lean on. So
you're not wrong. You're not wrong. I mean, you know, you can't, you know, discount the value of having a good, strong support system to, you know, support you when you need it and put a foot in your rear end when you need that. And
yes, sir.
Trust me, my sister done that.
Yeah. Yeah.
But, you know, I guess we got everything resolved as far as today, and we can take it up Monday and go from there if that pleases the court and the Commonwealth.
Yeah, that works.
Mr. Bell, when will you contact